Former Trump Chief of Staff Mark Meadows did not show up today for a deposition before the House committee investigating the Capitol riot. After Meadows defied the subpoena, his attorney released a statement saying, quote, "It would be irresponsible for Meadows to prematurely cooperate without a ruling on whether he's still covered by former President Trump's executive privilege." Executive privilege traditionally expires after leaving office. The January 6th committee was dealt another blow last night. A federal appeals court is blocking its request for White House documents, at least for now. This allows the former president's team to prepare an appeal. For some legal analysis of all of this, I want to bring in CBS News legal contributor Keir Dougall. Keir, great to see you. Why did the appeals court make this decision, and do you expect ultimately these documents will be released?
I do expect the documents to be released ultimately, but the problem for the appeals court is that once the documents are in fact released, then President Trump is no longer able to seek to make the claims that he's making. He effectively, once the horse is out of the barn, the appeals court loses its ability, if it were to choose to do so, to grant relief to President Trump. So this stay by the appeals court, while it considers the substance and the merits of President Trump's appeal, that stay is purely procedural. I do not believe that it is telegraphing a future win for the former president.
And Keir, the lawyers for the former president and his allies have defended their lack of cooperation by continually invoking executive privilege. What would it take for that defense to hold up in court? And what is the official stance on whether executive privilege extends once an administration has ended?
Right. So this is a contest between effectively between two branches of our government, between the legislative and the executive branch, and this is always has been throughout the history of the republic. It's been fraught territory, and what the executive privilege itself says is that the president is asserting that the public and the Congress should not know facts, should not know the truth in service of a higher principle and a higher goal. Some of those are, for instance, that the president should have the ability to receive the candid advice of his senior officials, or should have the ability to deliberate behind closed doors, while making a decision for the nation. So I just want to tweak the language slightly, Tanya. Executive privilege does extend beyond a particular administration, if it's applicable. The real question is who gets to claim it. Mm-hmm. And the dispute here is whether the incumbent president or whether the former president has the ability to claim executive privilege.
It makes perfect sense. So Keir, former Chief of Staff Mark Meadows could be held in contempt, such in the same way that former White House Chief Strategist Steve Bannon was. Why is the Justice Department sort of dragging its feet, or it seems to be, in terms of indicting him? Why do you think that hasn't happened yet?
Right. Well, I think the sort of the core issue is this a slam dunk? Is this something that's simple, or is this something that perhaps has some wrinkles to it? So understand the context that the Justice Department is operating in. It has to decide beyond whether it can prove beyond a reasonable doubt effectively that Bannon, and now if Mr. Meadows is referred for criminal prosecution, whether or not they have a good faith argument about the executive privilege. And so in that context, the question is, all right, we may all think, as I do, that the former president does not have, he's not the decider when it comes to executive privilege once he's left office, that the decider is President Biden. But those questions are right now being litigated in the context of a congressional subpoena. It's the appellate stay we just talked about. And so the question is, for the Justice Department, is Mr. Bannon, Mr. Meadows may be wrong, but do you want to say that it's a crime to argue that it's wrong, that there's no good faith argument available to Mr. Bannon or Mr. Meadows, potentially, if he's referred, about the operation of the former president's claim of executive privilege.
Right.
That is a tall order for the Justice Department to consider.
Indeed. But Keir, pulling out now and looking at the broader picture, Mr. Trump and his allies have fought subpoenas and investigations even when he was in office. In your view, has the power of congressional oversight been irreversibly weakened over the past few years?
Well, I don't think so, but certainly President Trump's strategy in several of these matters appears to be one of running out the clock. And given that the courts in civil cases, that they have an immense workload, they need to consider these issues carefully, they take a while. In a criminal case, you've got a very high burden of proof. When Congress goes to the judiciary and asks for help in a civil case, or to the executive branch and asks for help in a criminal case, they're asking for help from another branch. They continue to have their own inherent authority to press for the compliance with their demands and their subpoenas through sending the sergeant at arms out to arrest people or to seize documents. They continue to have that authority, and I'll be waiting to see whether or not they choose to exercise it. It would certainly focus the attention of the American public, and be a step that the Congress hasn't taken in almost, approximately 90 years. But that step remains available to them, and it is a very powerful tool.
Absolutely. Well, Keir Dougall, thank you so much for joining us. As always, we appreciate your legal expertise.
Thank you, Tanya.